We'd ask you to please adhere to that. We have a lot of people that we need to hear from today. So I recognize John Seago. You are testifying on behalf of Texas Right to Life and yourself, and you are for House Bill 44. Is that correct?
Yes, sir.
Okay, you may proceed.
Chairman, Vice Chair, members of the committee, thank you for the opportunity to testify. My name is Dr. John Seago. I'm a published bioethicist, and I serve as the president of Texas Right to Life, the oldest and largest statewide pro-life organization in Texas. I'm testifying in support of House Bill 44. House Bill 44 and its companion, Senate Bill 31, are negotiated bills, and they are continuing to be negotiated as we speak. This is a complicated topic. It's a critical topic, and we appreciate the committee's seriousness and questions that we've already heard so far. There are a lot of factors in this, even for you to consider. There's original legislative intent for 14 years. There's how that legislative intent was translated into a new chapter with the in 2021. There is case law, 2 different cases relevant to this. There's an attorney general opinion on this, and there's the bill before you. So can't quite do it justice in 2 minutes, but the fact is that Texas bans elective abortions. However, Texas law has always and today allows medical intervention when necessary to save a mother's life and avoid impairment of a major bodily function. Similarly, our law does not prevent treating a woman who is experiencing the heartbreaking situation of ectopic pregnancy or miscarriage. However, there has been a barrage of misinformation, there has been confusion, there has been even malicious lies about Texas pro-life laws. For example, the New England Journal of Medicine opinion piece quoted a doctor who authoritatively and wrongly asserted that Texas law requires a pregnant woman to be on death's door. That's their phrase. It was a group of authors on that opinion piece that women have to be on death's door for them to intervene. That is not true at all. There is no imminence requirement in Texas law. There never has been. It could be a foreseeable complication. The Supreme Court affirmed this. The Texas the Texas Medical Board has affirmed this. However, that misinformation that's coming from usually trusted sources is not just wrong, it's absolutely dangerous, as we've heard. There are real-world impact. And these types of mischaracterizations break down, and we see that when doctors are attempting to practice in good faith, use their reasonable medical judgment, they are genuinely confused about what pro-life laws do. And we've even heard stories of doctors knowing what the law says. However, their lawyers come in and interject and stop them from practicing best medicine. That's what the purpose of the Life of the Mother Act is aiming towards, is restoring that confidence to medical professionals and to educate physicians and their lawyers about the law. Now, I can go into details about specifics in the case, specifics in the bill, but generally, the goal is to make sure all of the laws match, to make sure that doctors and their lawyers only have one place in law to look to make sure that if there is threat of liability, they know what the standards will be, and to make sure that we're educating doctors on those, which in our opinion is the biggest problem right now.
Okay, thank you. Okay, we have Jennifer Allman, Executive Director of Texas Catholic Conference of Bishops. You're testifying for House Bill 44, is that correct?
That is correct.
Thank you.
My name is Jennifer Allman, and I'm the Executive Director of the Texas Catholic Conference of Bishops, testifying in support of House Bill 44, the Life of the Mother Act. Supporting pro-life laws is a part of our history and heritage as Texans. The state of Texas has repeatedly and throughout our history passed legislation to recognize and respect the dignity of unborn human life. As a result of court rulings, we have multiple laws on our books protecting human life, but not all of these older laws match up with current medical practice or definitions. As the Dobbs case allowed Texas to fully protect unborn life again, not all healthcare professionals or healthcare lawyers had the expertise to understand the multiple statutes on this issue. HB44 ensures that healthcare professionals and the legal professionals advising them have clarity in how our laws protect both mom and baby. It reflects our state's profound respect for mothers and children and ensures that healthcare providers have a clear understanding of their duty to provide life-saving care to mothers and unborn children. The unification of definitions should give mothers in Texas the security that their health and life will be respected and protected. Pro-life advocates can also be assured that this bill in no way allows for additional exceptions or expansion of legal abortion in Texas. After listening to the last panel, I just want to say that the Texas Catholic Conference of Bishops would not have participated in the negotiation and discussion on this bill if we did not believe it was necessary to improve the protection of the health care of mothers and babies in Texas. This is not a compromise bill where we gave something up. It's a common ground bill because we all believe in the protection of both mother and baby. Thank you.
Thank you. Okay, I have Ashley Lehnertz, and I may be mispronouncing that. I apologize if I am. Texas Legislative Director for Texas Right to Life, and you are for House Bill 44. Is that correct?
Yes, sir.
Thank you. You may proceed.
Yes. Good morning, Chair Van Dever and members of the committee. My name is Ashley Lehnertz, and I serve as the Legislative Director for Texas Right to Life, and I am testifying in support of House Bill 44. While abortion remains an ever-present issue in Texas, as we estimate 30,000 preborn Texans are still killed every year due to abortion pills entering the state and out-of-state abortion travel, Texas Right to Life supports the intent of House Bill 44 and other pro-life bills that aim to help build our culture and save mothers and children. Texas has led the way in protecting both mothers and preborn children. Our laws have allowed physicians to intervene in cases where a mother's life or risk when a major bodily function is threatened. Miscarriage and ectopic pregnancy treatments have been allowed under our law, and no doctor has been charged for providing necessary medical care in emergencies. However, despite these facts, liberal media outlets and abortion activists have worked to spread confusion, falsely claiming that pro-life laws prevent doctors from treating women in crisis. This misinformation has created a chilling effect in hospitals where physicians have hesitated to provide care, not because the law restricts them, but because of fear of legal consequences due to misleading narratives. This is not a failure of the law, this is a failure of education and communication. House Bill 44 aims to remedy this by ensuring physicians and their advising attorneys receive clear and accurate information about what Texas law allows. The most important parts of HB44 would establish consistent legal definitions, creating legal protections for doctors acting in good faith, and mandate free continued education courses for physicians and their advising attorneys through the Texas Medical Board and Texas State Bar, eliminating the unnecessary fear and confusion that has been manufactured by the abortion lobby. Texas laws are designed to protect mothers and their preborn children. HB 44 ensures physicians and their attorneys fully understand these protections. Thank you, and I kindly urge you to support this bill.
Thank you for your testimony. Okay, Chair recognizes Joe Poyman, PhD, Executive Director. You're testifying on behalf of Texas Alliance for Life. You are for House Bill 44, is that correct?
Yes, sir.
Thank you.
My name is Dr. Joe Poyman. I'm Executive Director of Texas Alliance for Life. We strongly support House Bill 44. We are especially excited about the continuing medical education and continuing legal education pieces of this bill. In 2021, the legislature passed the Human Life Protection Act that went into effect in August 2022, a few weeks after the Supreme Court overturned Roe v. Wade in Dobbs. That law completely protects unborn babies from elective abortion throughout pregnancy. Reported elective abortions have plummeted from thousands per month to zero. However, the law has an exception to allow doctors to perform medically necessary abortions in rare and tragic cases when the pregnancy endangers a woman's life or major bodily function. The Texas Supreme Court has upheld that exception as constitutional and clear for doctors in two cases, in Ray, Texas, and Texas v. Zawoski. The Texas Medical Board has promulgated rules explaining the exception to physicians. According to data from the Health and Human Services Commission, doctors have reported performing 151 abortions under the medical necessity exception since Dobbs through November 2024, about 60 per year, virtually all in hospitals. No doctor has been prosecuted, sued, or sanctioned for any of those 151 abortions. No woman has lost her life for lack of an exception. From the HHSC data, we can see that doctors have performed abortions in hospitals to save women's lives or major bodily function before Dobbs. And doctors are performing abortions to save women's lives or major bodily functions after Dobbs at comparable rates. After accounting For abortions performed for cases of fatal diagnosis of the unborn child, which are allowed before September 21, there is likely no substantial difference. Hospital attorneys and doctors need to know this so doctors can treat their patients with 100% confidence and so that pregnant women can receive the care they deserve. Thank you.
Thank you. Members, questions of this group? Representative Alcott.
Thank you, Mr. Chairman. Mr. Seago, would you be willing to comment on the conflict in existing statute?
Yes.
Because I've been hearing this repeatedly. There's a
Yes.
conflict in existing statute. I'm not saying there's not. I just would like
Right.
to know a little bit more about it.
Yes. So the biggest conflict is between 171 and 170A. And that is where the Texas Heartbeat Act is, and then where the trigger law was. The legislative intent for 14 years was with 171, and so there is a difference with the trigger law, some of the phrasing, and some of that was needed, like the use of the term reasonable medical judgment. That's a big difference, and I think that's leading to a lot of confusion among our friends, is the difference there. There's also some older laws, like the 1925 law that was referred to earlier. It just said on medical advice. It didn't even use the term medical emergency. As an exception, it just said an abortion was allowed on medical advice. That's a lot broader than medical emergency.
And where was that again?
That's in the 1925 pre-Roe statute that banned abortion. And the state of Texas has been arguing that is a valid law ever since Roe was overturned. They are arguing that in court. They've argued it in bills in 2021. The position of the state of Texas is that is a valid law and should be fully enforced. However, because it said medical advice, that's a problem. There were some other areas in law where it roughly describes a medical emergency but doesn't use the exact term. And so there are some areas, and if that's all that this bill did, I think that this hearing would be a lot simpler. But obviously, we're trying to make sure that doctors can use their reasonable medical judgment and provide education to doctors as well.
Thank you. And Dr. Poyman, I have a question for you. In your comments, it sounded like it actually gave pretty good confirmation that the laws actually are working when I listened to what you said. It was very well articulated, and it sounded like things are working really well. And that's,
Yes, sir. We think the law is saving babies' lives and it's saving mothers' lives. However, I think this bill is very helpful because the CME is needed. Not all doctors, at least anecdotally in some of these media reports, are not getting that message.
So do you think that the laws are adequate, even if they are somewhat conflicting about that, in that if the attorneys for the hospitals and the hospitals themselves were simply better educated, does it really need to be done through statute?
Well, let me just say, I think this is a really good bill. We're 100% behind it. So I'm really glad that Chairman Guerin is bringing it.
Okay, thank you.
Members, other questions?
Yes, Chairman.
Representative
Thank you.
Johnson.
John, I appreciate your statement that this is a critical issue. You're not suggesting that this is not a situation that needs to be resolved because people are dying in hospitals currently, right?
I do not think that the stories that we know of are because of the law. I think it's because of confusion and the misinformation, even from reputable sources that we've been referring to.
And so the three stories, the three women, Portia, Imuzi, Gisele Barnica, and Navia Crane, nobody's suggesting that these women did not die in the course of a pregnancy complication on this panel, right?
I think the discussion is about what led to that confusion, especially in the case of Crane.
Okay.
I would say that those cases are exactly why the law is needed, because if even one mother dies because there is confusion among healthcare professionals and their attorneys, then we need to clarify so that there is no longer confusion. And that's why the law is needed.
Agreed. Thank you. We can all agree that this medical exception question is one that is real. It is not fictional. It is actually occurring, and it is something that's why the groups have come together to say we need to solve this particular issue. And so House Bill 44 is about medical exceptions. As y'all have said, this is not a choice bill, right? This is not effectively my side because I am pro-choice. This is not my side getting anything, right?
Correct.
And I want to talk about the other way. Would you equally agree that this is a medical exceptions bill and that this is not an attempt to backdoor the 1925 law?
So the debate on this bill is about how narrow or wide the definition of medical emergency should be in Texas pro-life laws.
Okay.
This is not a way to revive a law that, in our opinion, is already a live option. It's already a live bill, and whatever's going to be prosecuted under the 1925 law today is not going to be affected by this.
So tell me what could be prosecuted in your mind today in the 1925 law.
Well, I think there's. I shouldn't have said today. There is a court case ongoing, and so nothing is going to be brought until that case is decided. But that case does say it is illegal to furnish the means of an abortion for someone else, and so that is a little bit broader, and it's honestly untested when it comes to aiding and abetting. And so, buying illegal abortion pills and handing them to someone, does that mean I'm furnishing the means of an abortion? I think it would, and I think once that lawsuit is settled, that individual who is illegally trafficking abortion pills could be prosecuted under the 1925 bill, and that's happening. People, over 19,000 Texans are ordering abortion pills online right now. There's a story out of Houston of a husband who got these pills illegally and snuck them into his wife's water. That is a very real issue that I'm encouraging in other bills the legislature to address this session.
And so if the legislature wanted to specifically address or speak to that particular issue, the legislature could pass something right now saying that they are putting the 1925, all those provisions into effect.
Well, the state of Texas has already said 1925 law is in effect, and they're arguing that.
They're arguing that, but that is potentially an open question, correct?
A court is looking at that question right now.
But you personally believe that that law should be enforced right now?
Once the court case is settled, absolutely.
And so when you talk about furnishing the means, as you've said from that particular law, are you intending to go after the prosecution of women who have legal abortions in other states?
So Texas has, in all of our other pro-life laws, has a very explicit policy that they will not prosecute women who are seeking abortions. That's on the civil side, the criminal side, the administrative side. That's across the because that 1925 law was not passed in this political environment, in this political debate. There is no language in the 1925 law to protect women from being prosecuted under that.
Say that again, because I got confused.
There is no that same provision that we have in the Texas Heartbeat Act, we have in the Trigger Law, we have all over our pro-life policies in the last 30 years. That policy is not in the 1925 section, the law that we're talking about.
So if that 1925 law were to go into effect, there would be a conflict as to whether or not the woman should be prosecuted or not under the laws of the state of Texas.
There's a lot of case law since then that would be relevant, and I can provide those citations to you. I'm sure you know them very well, actually. But
I'm just asking, as a policy provision, you're not supporting this bill because you think it would create a provision by which you could go prosecute women?
No, that is not my purpose for supporting this bill.
Okay. And then for furnishing the means, I want to talk about where you draw that line, which is this law, because it is a medical exceptions bill and it is not a choice bill. So we're not talking about rape, we're not talking about incest, we're not talking about fetal abnormality. But you recognize that other states would allow the legal termination of, let's say, an 11-year-old little girl who's raped. Other states would say that there's an interest in that 11-year-old little girl being able to have her family help her make the decision on whether or not she wants to carry or be forced to birth her rapist baby.
I might have been confused. Texas doesn't have the ability to
Agreed.
determine policy for other states.
Correct. Texas has the ability to determine policy for our own citizens. You are taking the position that Texas is not allowing an 11-year-old child victim of rape to terminate her abortion, because we're not talking about rape, incest, or fetal abnormality in this bill, correct?
That debate is had every time a pro-life bill comes to the House floor. I'm assuming that our state will continue to have that debate.
But that debate is not happening in other states, and there are other states that allow the lawful termination if the family determines that they do not want that 11-year-old to have to bear the child of a rapist. That's their decision. And other states
Yes, of
authorize
course.
that
There's
decision,
a
right?
wide array of laws regarding abortion throughout the country right now.
And so it may be legal in other states.
Correct.
And when you talk about your analysis on not prosecuting the women, but you made it very clear that you would pursue the legal theory of prosecuting people who furnish, that would mean a grandmother who takes her 11-year-old granddaughter who's been raped across state lines to terminate the pregnancy of her rapist could be prosecuted under your theory if the 1925 law were to go back into effect.
The furnishing the means of an abortion has nothing to do with traveling outside of the state.
If that grandmother decides to remain in this state and pursue the option of prescriptive medication to keep her granddaughter from being forced by state law to bear the child of her rapist, you are saying you would prosecute that grandmother in the state of Texas.
I'm not quite sure if what you're talking about is something that would be legal or illegal, but what I am saying this law would apply to is illegally buying dangerous drugs, giving them to someone, which is currently, it's currently illegal in Texas. There's currently civil liability. If you are recommending that someone could be doing something illegal, I think yes. If they're breaking the law, then that 1925 law could be one instrument amongst many others that we have against the individual breaking Texas law at the danger of the mother and the child.
And you talked about aiding and abetting.
Mm-hmm.
Again, there are legal activities out of state that are criminal here.
Mm-hmm.
My nephews go to Lake Charles to gamble. I give them $500 to go gamble. You're not expecting the state of Texas to prosecute me for aiding and abetting and them engaging in legal conduct outside the state, are you?
That's not my policy area.
I understand, but I'm trying to be consistent in policy in the state of Texas and that we're not misapplying.
I think
right?
what is the jeopardy, what's being debated, sorry.
Yeah, and the point being, this is a debate that is raging, and I'm trying to get confirmation from you that this is not your intended purpose of this bill, because we are not trying to suggest that we are reauthorizing the 1925 law in total. We are simply saying that we are creating an exception to the threat of prosecution against the hospital community, correct?
Correct. This bill says nothing new that Texas has not already affirmed, that they think that law is valid.
And the problem is Ken Paxton is the one that dropped an entire footnote in his letter after Dobbs of the 1925 law in total against the hospital community in the state of Texas, correct?
I'm not advised.
So when the statement was it's liberal media that's scaring people, and I don't mean it actually as a criticism. I really want to stay focused on this bill. But this is not a political thing for me. This is about saving women's lives and getting doctors back to practicing care. But when you say that the liberal media is giving misinformation on this, it was actually the Attorney General and his letter and statement that dropped the entire footnote of the 1925 law. And that's why I'm trying to say the threat is not coming from the media. The threat is coming from Paxton.
Our position is not that threats are coming from the liberal media, it's that they're misrepresenting the law, like the New England Journal of Medicine opinion
I don't care about
piece.
the New England Journal of Medicine. I care about the Attorney General, Ken Paxton.
Okay,
And I would love to ask him these questions, but the Attorney General's office also refuses to come testify before the committees of which they have authority. So the threat is real, and the threat is being done by a state agency, correct?
Not advised.
I mean, you can print this like I can, right?
Yeah.
I mean, my focus is on
We've
this.
not been talking about threats. I think I'm a little confused as why you're talking about threats. We're saying
Because you made this statement after you testified in the Senate to the Chronicle, and I want to make sure it's very clear that the focus on this bill is a medical exception And the focus on this bill is not to hijack it or backdoor it and do anything that could allow for the prosecution of grandparents taking care of their granddaughters or husbands taking care of their wives that have a fetal abnormality that need to go out of state for care or in this state for care.
If I may respond.
Sure.
So whenever I said the media misleading narratives or false narratives from the media, I wasn't referring to Ken Paxton's footnote there, but I was referring to the cases that you have mentioned with Portia and Nevaeh Crane and others who ProPublica has said they died specifically because of pro-life laws. Whenever those women were not treated properly, and we would argue it's medical malpractice, and that those doctors I would say those doctors should be investigated or sued or held liable for what they did. And I have friends who have experienced miscarriages and pregnancy complications, and I think it is disgusting that our media would make women afraid to go receive medical treatment at those times. And so that's what I'm referring to as dangerous, misleading narratives from the media.
And I appreciate that point, because I also want to say what it's painfully cautious to me is that this discussion of trying to fix the healthcare crisis does not become an additional concern that was brought up in the 1925 law to suggest that we should again scare people from getting care, or scare grandmothers or anybody else. And that's why I'm asking you guys, because that's the suggestion. You're not suggesting that this is anyhow a statement of reviving the 1925 law, because if the legislature wanted to do that, they could take the bill up and pass it themselves, right?
Yes, this is not trying to say any law is or is not already active. It's just trying to make sure that there's clarity for doctors and lawyers whenever they're treating women in medical emergencies.
Okay, thank you.
Thank you.
Representative Pearson.
Thank you, Chairman. This is for Ashley, John, and Joe. We've had a lot of debate over the language of this bill. We've established that the Supreme Court says that life-threatening, and I'm just trying to really understand if you guys agree with the definition change of life-threatening, that it has now been testified to does not necessarily mean life-threatening. You're okay with this language?
So the difference is, when you look at 171, the definition of medical emergency in 171, for 14 years there had been two different interpretations of that definition, a two-prong versus one-prong definition. When it was copied and pasted from 171 into the trigger law, it was changed, and the grammar changed it. And so a lot of our friends who have worked on those pro-life bills for 14 years in this building, they always had a very clear legislative intent that there were two different situations. However, whenever it was moved over into 170A, because the grammar changed, it was untenable to hold a two-prong interpretation anymore. So again, this is what I meant by going into all of the legal stuff. So the goal, this is an important policy discussion. Does Texas want to allow substantial impairment of a major bodily function to be a standalone criteria or not? That is the debate, the most substantial policy debate that Republicans are going to have of whether we support this bill or not.
And right now, the Supreme Court says no.
The Supreme Court looked at the trigger law, did not look at the 171 definition, and said in the trigger law that both the risk of death and the substantial impairment of major bodily function have to be life-threatening.
And so without changing the language, I think most people would agree that we don't want to restrict physicians from doing their jobs effectively. Would you still support the bill without the language change?
Which language change?
The life-threatening language change?
Yes.
Okay, thank you.
Representative Jones.
Thank you for coming to testify. I always find it nice when the different sides actually agree on stuff, which means it's nonpartisan. I just want to make sure of one thing. Whether anyone thinks that the liberal media did anything and caused confusion, I'm moving that out of the way. Would you agree with me that all of the different laws about this issue or at least some of the different laws, have different definitions. Is that accurate?
Yes.
Okay. Would you also agree with me that if you were going for legal advice and you're a doctor and they all take the Hippocratic Oath, that they want to make sure they don't do anything to run afoul of the law? So they go to a lawyer, and a lawyer reviews the various laws on the same subject with different definitions. Would you agree with me that there needs to be clarity on that, so there's one answer, so that the right answer is always the right answer? Would you agree with me on that?
I think what I would say is the ITOP data shows us that 151 times the lawyers and doctors got it right, but we know from cases both in the media, because they were made public that way, that some doctors and lawyers did not know what to do, and that had fatal consequences, and that's why we need this bill.
Right. So one death is too many. Would you agree
Correct,
with
yes.
that? Whether it's based on the liberal media, if that's what you agree, or whether it's based on the law. Is that accurate?
Yes.
And that is why you are saying that you agree with this, is because it takes away any guesswork and it gives a clear standard for what a medical emergency is.
Yes, and that makes it more easier if it is malpractice to go after the physician for malpractice. But I can see why it would be very confusing to a physician and doctor and legal provider who have not been looking at these cases over the years and have not studied these laws. And we've seen that in the evidence of the deaths and the severe impact on reproductive, health for women who will have lost their fertility because the doctor didn't know what to do.
And I'll also say this, apart from it gives you a clear standard civilly to go after a doctor for medical malpractice, it also will cause problems criminally to actually prosecute somebody who did what the law says you couldn't do. Would you agree with me?
Yes.
So it's better all around, civilly and criminally, to establish what it is so that we know whether you are following the law or whether you're breaking the law. Is that accurate?
That is correct.
Thank you so much. I appreciate you.
Representative Frank.
Yeah, thank you very much, Chairman. Do you feel like this bill, and I'm going to start with you, Ms. Allman, do you feel like this bill changes the prioritization that the current law places on mother and baby/fetus? Does
No.
it change the current?
No, we
law?
believe that the bill respects both mother and baby and gives the physician and the mother and the father involved in the case the opportunity to recognize that their unborn child isn't going to survive, and they want to make sure that the mother can survive. And we think that clarity is important because oftentimes in healthcare we can foresee a death. There's a difference in whether we help that death along or whether we let that death occur naturally.
It seems to me it does at least partially change the Supreme Court's interpretation of that.
It clarifies, yes. So the Supreme Court, as Ms. Pearson was asking, as well, Representative Pearson as well as Dr. Segal were explaining, the Supreme Court interpreted that the law requires both prongs. Those of us who
Right.
worked on the law did not intend it to require both prongs because we recognize the threat to women's lives when a major bodily organ or major bodily organ system is threatened and they could end up on dialysis for life.
So I understand the reason to do that, to make sure that we protect the mother at every case. I'm also trying to weigh that with when you have a significant number of professionals in this field that literally believe that that is only a clump of cells. What in the law makes sure that they weigh those, even if they may not personally, but as a state, we have said that is, that is, I guess we haven't said it's a patient, but we have said it is a life worth protecting. So for somebody who operates in this field, why would they, what in the law protects or makes sure that they pay attention to that?
I believe there's other provisions in Chapter 171A that take care of that. I don't have the statute in front of me, but I think it's also, you have to reconsider like what kind of cases we're talking about. This is not someone who's driven to Planned Parenthood at 6 weeks pregnant because they don't want their baby. This is typically a woman who very much wants her baby and is at 20 weeks pregnant and is having a medical emergency where she recognizes she has lost her child, even if it's not fully dead yet. Her child is in the act of dying, and the only way that she can survive to remain here to parent her other children is to accept that death and protect her life. And that's what the bill seeks to strike a balance for. And I think you're right that there are some doctors who would have no problem with immediately choosing the life of the mother and not caring if the baby could have survived and they didn't do everything they could. You're right, there's a handful
Or doing it
of those.
for any reason.
Right, there's a handful of those.
As
But I think the ITOP numbers show us that's not most doctors because they're consistent
But that's
before and
under
after
current law, though.
DOPS. That's under current law, but I think it'll be consistent after. And if it's not, we do a great job of coming and passing pro-life laws at this legislature, and we can come back and fix it.
Okay, thank you very much. Thank you, Chairman.
Representative Cunningham.
Thank you, Mr. Chairman. Just a few questions for, and anybody on the panel can answer. In reference to this bill being a back door, is this bill a back door?
Absolutely not. Absolutely not. This is very clear. It does what it says, and it says what it does, and it is basically to take the definition of medical emergency in the Human Life Protection Act, which was passed in 2021, and transfer that into the other 3 major abortion laws so that doctors know. The exception, of course, is the critical function in all of these. Doctors know exactly what language to look at. With respect to the 1925 law, is actually passed in 1854. And never were women prosecuted under that law, successfully prosecuted in Texas. Never were they. There's some other speakers that will make that point. Never were they. And we would never expect, it hasn't, no woman has been prosecuted since Dobbs. The Attorney General says that law is in effect. No woman has been prosecuted. We have no reason to believe that anyone would be. The Court of Criminal Appeals has numerous decisions that said that law cannot be used to prosecute women on whom abortions are performed. So that is very clear. So it is simply about making sure doctors know exactly what language to look for when determining in reasonable medical judgment whether the woman has the pregnancy imposes a serious risk of death. Risk of death is still in the law. Risk of death is still in law, or the pregnancy poses a serious risk of substantial impairment of major bodily function. We have other states with virtually the same law, with virtually the same reporting rates as you see here. So that language is not being abused in any other state that has similar laws to this exception that this bill has. That's why we believe this is a very good bill.
Okay, and so you had mentioned, I'm still talking. You had mentioned one case, I believe, this Zarowski, and we're talking about this language now, threat of life, death, whatever. But before I go back to that, it's amazing that we've gotten everybody here together and we're on the same page. So the question is, what was in the bill that you guys didn't like? That all of a sudden now we can agree?
You mean the original
The
draft
original
of
bi-
this
yeah,
bill or
right.
the original law?
Yeah, the original draft of this bill.
Well, that's not before the
John?
committee today, so.
Well, I'm just trying to put it together because the question is coming up because we're talking about language, and there was a hearing, I believe, on the 27th that said that we should not be using this language. We should not be referencing this law that I'm looking at here, Texas v. Zarowski. So, and undoubtedly, it brought it together, and now we've got HB44, which I'm in favor of too. But I'm just asking the question. It's asked and answered.
Representative, thank you. So this is a negotiated bill, and negotiations are continuing. Even Friday afternoon, there
That's
were
the answer I wanted to know. Then
groups that were sending amendment language, and obviously Senator Hughes is quarterback on the other side of the building, and he's getting amendments from members and organizations. So this is very much a work in progress, and I think this hearing shows these are critical issues, and there's a lot of important questions that need to be answered.
Thank you, John. Thank you,
Can I
Mr.
add
Chairman.
to that,
Yeah,
though?
yeah,
As it's a
add
work
to
in
it.
progress, we all committed to working on it together. And so as amendments are brought, the agreement is that all of the organizations that Lisa Kaufman outlined would have to agree to those amendments so that it remains a common ground bill to protect the life of the mother. We don't want this bill hijacked for either side's agenda. This bill is supposed to be to protect moms because that is our common ground.
Thank you, Mr. Chairman.
Representative Busey.
Thank you, Mr. Chairman. I appreciate what you just said, the common ground bill, and that's what we're dealing with here. And I've heard from all four of you that you think what we're doing is clarifying the law to make sure the life of the woman is protected. Is that correct? Anybody disagree with
Correct.
that? And not inherently changing the law, and we've had a debate here about who's responsible for the confusion, but we all agree that we are doing this to create clarification under current interpretation of law.
Correct.
Everybody. If somebody doesn't, I'd love to hear it. In addition, for intent, and you just talked about, sir, about, no one's ever been gone after the women and prosecuted, and I appreciate that. We want to make sure that doesn't happen. And also, I think to Representative Johnson's point and some of the questioning earlier that I didn't hear a clear answer on, what about the immediate family that is helping them? Are we making sure we're not going after them as well? And so I'm just curious if anyone feels that we should be doing that or that we shouldn't be doing that, and if you think that's clear or needs clarification. Anyone on the panel?
With Texas Lines for Life's approach is that it is not legally possible for someone to help another individual to have an abortion within Texas because of the Human Life Protection Act and these other statutes. In terms of out-of-state abortions, Justice Kavanaugh, in the concurring opinion in Dobbs, did say that his belief, and probably there's at least other 4 judges who would agree with this, his belief is the Constitution principle of interstate travel does not means that we cannot prevent individuals from going out of state for abortions in a state where it's legal, like the gambling analogy. So now, as far as helping, that's not been decided by the courts and by the U.S. Supreme Court. There was an opinion out of Alabama in which a federal district judge did say that Alabama may not prevent someone from helping an individual go to another state for an abortion. That was one federal district judge. I can get you that opinion if you want. It hasn't been decided more broadly than that.
Well, and I think to Representative Johnson's point, we're talking about potentially the idea of a grandmother or a mother helping their teenage daughter who we can't expect to be able to go out of state.
I don't think anybody will be able to say that a parent or a guardian can prevent someone from going out of state for an abortion. But again, the courts haven't addressed those yet.
But it's not y'all's intent to try to say otherwise.
Not Texas Lines for Life.
Anybody else feel different on the panel?
Not through this legislation.
Yeah, not through this bill.
This bill just addresses the clarity on what pro-life laws allow. This is not to restrict anybody or add any enforcement tools.
And you don't think this bill, through this clarification, would change anything currently under the law otherwise that could restrict that?
No, sir, absolutely not.
Everybody
This bill
agrees?
does not.
No.
Mr. Segal, you agree with that?
I mean, no, there's an ongoing lawsuit right now about
Sure.
the validity of that bill. That's going to be settled. This may help the state in that case to reiterate that every session, but they've already, that doesn't really help them. They've already argued just 2 sessions ago that law is valid. So this argument doesn't really change.
Your intent in supporting this bill is not tied to that.
Correct.
Thank you, Mr. Chairman.
Representative Johnson.
Yeah, thank you. And as you can see, and I apologize, I don't mean to get heated, but I am desperately aware of why we need this legislation and that it needs to pass and that it is important for our healthcare community and for protecting and saving women's lives. I don't, just as you said, Jennifer, we don't want this hijacked. And I appreciate what y'all have said about the intent. But to make sure that this doesn't get derailed or taken off track about the discussion of 1925 law, to make it clear, because you said there's other bills working their way through that's the debate. Would you guys be willing to support an amendment on this bill to make it clear that this is not attempting to revive the 1925 so that there's no question it's put to bed?
Like I said, this is a negotiated bill. We're currently negotiating amendments, and that's one of them.
And so you would support making this clear, this is just medical exceptions and not attempted to revive 1925. And I appreciate that because that's so important to make sure this thing goes through the right way.
I want to be careful. There are several amendments in negotiations. I don't want to interrupt that conversation.
How about for the rest of you from the other organizations, since you're such an important stakeholder, would you equally agree that an amendment to make it clear that the language is clear, this is not any attempt to revive the 1925 or other components of it is not what we're doing here?
We have to see the language of the amendment, but it is not our intent to do that, and we would not object to an amendment that is agreeable to all parties that ensures that this is not about the 1925 law, or an amendment that says there's no intent to prosecute a woman seeking an abortion. The bishops have never supported the prosecution of women seeking abortions.
Yeah, and when we say that, because it then takes us to grandmother and everything else, and those are other bills being debated, and that's why I want to make sure. Is there a commitment from you all that we're not trying to bootstrap that other argument? We're really trying to focus on the medical community, and that's why I'm asking about that.
And I think this bill narrowly does, so that's why we're so careful about amendments, is we don't want to open up those other debates and other conversations for another day. It's a rare opportunity to have a common ground abortion bill, and we want to protect that.
Representative, in our view, this bill does nothing to, and we would oppose it if it created any way to prosecute women on whom abortions are performed or who self-abort.
And I appreciate that, but as you can tell, the other side is equally going to get, that takes us off in another discussion. My question is it possible that, would you be willing to agree to a language that would make it clear that this particular statute and the provisions that are being changed are purely for medical exception and not intended to revive 1925 law in total?
Yeah, I don't know what you mean by revive, but
that's the whole debate, right?
Does do any more than it does, then it doesn't do anything to that law than it is currently is in effect. Yes, that's our intent.
I appreciate the willingness to talk about that. Thank you, Chairman.
Representative Collier.
Thank you. And I just want to make sure that we all understand, because Dr. Pojman, I believe you said the 1925 law is not a 1925 law. It's a combination of laws that were passed. And
It actually goes back to 1854. That was my point.
Yes.
And it was just recodified in 1925. But
Okay.
yes.
But please define what so everybody, we're all on the same page, in the public who is listening, what is the 1925 law that you're referencing?
It was a law that protected unborn babies from abortion. Again, it was originally passed in 1854, and it's very simple. It's in civil practice, Texas Revised Civil Statutes. It's got 19th century language, early 20th century language that does not allow abortion except when the mother's life is in danger. And that's, it's very simple, and that has been around. And that is the law that the Supreme Court addressed and blocked enforcement in Roe versus Wade. And also, by doing that, blocked enforcement of all the pro-life laws around the country back in 1973. That's the law.
Okay. So the 1925 law that was codified, that everyone's saying that they agree, they're not trying to revive it, they're not saying that it's encapsulated in this particular HB44. It dealt with abortion, exceptions to abortion in a certain circumstances.
It had an exception for the life of the mother.
For the life of the mother.
But that language was not in modern language that doctors would look to today. And that's why what we really love about this bill is that it takes the language of the Human Life Protection Act, modern language passed in 2021, and inserts it into the what we're calling the 1925 law.
Okay.
So it's very clear to physicians and it does nothing, some of the questions, does nothing to create any ability for a prosecutor to prosecute a woman on whom abortion is performed or who self-aborts.
Okay. That's HB44.
Correct.
Okay, so that was what I was going to ask you then. I want to make sure, because I think Representative Busey, he was alluding to that, and just want to make sure, and I want everybody to answer yes or no, or their position on this question. Does this bill provide protections to a pregnant patient who has an abortion as a result of a risk, the reasonable medical judgment of the physician, there was a risk of death or substantial impairment of a major bodily function.
Yes,
It does provide protection?
yes.
This bill
Because
does.
because it's already in the law, very strongly in the law.
Okay. Jennifer?
That is the current law, and that remains the law in this bill.
Thank you.
Yeah, I would agree.
Yep.
Thank you.
Chairman, I'm sorry.
Representative Jones.
Another clarification. I heard something. I just want to make sure I heard right. In the states that use similar language to HB44, it's gotten away from any of the confusion that happened before that, and it's clarified. So, like for us, so that if we follow the suit of other states that use similar law, then this issue should be resolved about what is, I guess, substantial risk to the life of the mother, or whatever that terminology is.
I guess my point, Representative, was that those states that have similar language to what this bill does, two-pronged exception, we're seeing the same reported abortion rates in those states as we're seeing right now in Texas. You know, the rates, much smaller states. But so we have no reason to believe that doctors will misuse the language or abuse the language, will do nothing other than protect their patients and perform abortions in those very rare and very tragic cases when the pregnancy endangers, puts her life at risk or serious risk of loss of a major bodily function. We think that is, we're seeing in other states what we would hope to see in Texas.
So if I can say what you just said, then that means I understand it, and I want to make sure that I understand it.
Yes. And I could get you our data so you could,
That would be
we bring
great.
that by your office. I'll show you our
That'd be
data.
great. Maybe my colleagues want it too, but so doctors won't use or misuse this law for anything other than to figure out whether the mother's life is in danger or in danger of having a substantial injury to like a body function.
Correct.
All right, that's
Yes,
what I
that's
need
our
to know.
position. Yes.
Okay, thank you.
Representative Johnson.
I'm so sorry. Joe, you made a statement conforming this language into the 1925, and it, of course, made my trigger go up. Again, would you, because of that kind of statement that could be misconstrued as this bill as an attempt to affect that 1925 law, that's exactly why I'm saying that may be why we're asking for the amendment to make it very clear that this is not about conforming the 1925 law.
Yeah, I think the intent of the amendment is good. Of course, we just want to see the language, but we want to make it clear that no one should have a fear that the 1925 law is any different now than after this law, than before the law, with respect to prosecuting women or assisting anyone to have an abortion. It does not change it one iota. And if there's some language that we could put in the bill that would help that, subject to what the author wants, of course, and the other groups agree to, absolutely.
Thank you, because just as John said, there's 170A, 171 definitions, medical advice of 1925, and we're trying to make it very clear
Yes.
that we're trying to clean this up here and not bring this, as you say, 1850s law back in. And that's not what
We
we're
saw
doing.
some of those reports going around on social media and
Yeah.
emails and stuff, and we were frankly baffled.
Okay.
It
So we
looks
can
like
fix it
they're-
if we can do the amendment.
Absolutely.
All right, thank you.
Okay. All right. Thank you for your testimony. Chair calls Brooke Stroud, Kathy Sweeney, Tanya Russell, and Kristen Lanau.